Hey, welcome to Failure to Stop, the #1 show where police meet society and culture. I'm Drew Breasy. If you like this content, be sure to hit the like button and subscribe. As always, you can find more at failuretostop.com. So check this out. This is kind of what I want to do for you today. I want to help you become a better cop. I want to help you become a better citizen, and you can argue intelligently in the comments section of every single Instagram post that it goes against policing or that is anti-police, and we know that there is no shortage of those. So what I want to do today is review some constitutional amendments. I also want to talk quickly about probable cause, reasonable suspicion, and proof beyond a reasonable doubt. And as a bonus, well, you're just going to have to stick around to the end to find the bonus. So you may say, well, how is knowing the amendments to the Constitution that I already know going to make me a better cop? Well, listen, I had a good friend. He was an attorney. He still is an attorney, as a matter of fact. He was just appointed to a judgeship. We used to teach together, and he would always tell the students the same thing. If you can spout off the definition of probable cause, you will own that courtroom. You'll own the defense attorney. You'll own the honor and respect of the judge, and you will certainly own the jury because they will know that you know what you're talking about. Think back to your favorite song. Do you have it on repeat? Can you sing every lyric? If you can memorize these 43 words, you're probably going to own any courtroom that you're in, and you're going to take away any doubt that you have in your mind. Probable cause exists where the facts and circumstances within the officer's knowledge and of which they had reasonable, trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. So in order to stop somebody for reasonable suspicion, all reasonable suspicion requires is that you have an objectively reasonable basis to believe that the person you're dealing with has just committed a crime, is committing a crime, or is about to commit a crime. That's the difference. So you may only need reasonable suspicion to stop and detain somebody without their consent, but in order to arrest them, you're going to need probable cause. So say you're in a little argument in Instagram or on Facebook about the First Amendment. It's not just the freedom of speech, if you don't remember this. The first 10 amendments to the Constitution are known as the Bill of Rights. And the First Amendment, though very important because it covers freedom of speech, also covers some very important aspects like freedom of religion, freedom of the press, the freedom to assemble, and the freedom to petition the government. These are very fundamental rights that have had broad application in the last couple of years alone. So real quickly, the Second Amendment, it's not just a bumper sticker with some snakes on it that says, don't tread on me or whatever. Here's specifically what the Second Amendment says. It reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. A lot of veterans have that tattooed, shall not be infringed. So in today's context, let's take a look at the Kyle Rittenhouse case. Not only was that Second Amendment applicable because he had the right to keep and bear arms, the Second Amendment also protects the right of an individual person to keep and bear arms for the purposes of self-defense. So you had two things in the Kyle Rittenhouse case, and those came straight out of the Second Amendment, and that thing was ratified in 1791. So that's why people got upset when the prosecutors decided to prosecute this guy for defending himself, essentially. And the defense, Kyle's defense team, made a great case that that's exactly what he was there to do. And that's why he had to take the lives of the people he killed to defend himself. By the way, there was no such thing as traveling over a state line with a firearm. That was just a media narrative that was 100% created, and people still use it to this date. There's no violation for that. Now, we're getting to the juicy ones, but we always jump over the third for some reason. How about that Third Amendment? Does anybody remember what that was? I didn't think so. What that says is it prohibits the quartering of militia in private homes, either in war or in peacetime, without the consent of the homeowner. So the National Guard can't just knock on your door and say, hey, we're commandeering your place. We need a place to stay. Do you have any yogurt in the fridge? Or perhaps do you have snack packs of fruit roll-ups? They can't do that. That's against the Third Amendment. It was also ratified in 1791. So if you do have that happen where they show up looking for fruit roll-ups, refer them to the Third Amendment of the Constitution of the United States. Now we're getting to the juicy ones. The Fourth Amendment, also ratified in 1791, is the guarantee of the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, right? So it's about when people come into your house to search without consent. Do they have an objective basis and a reason to be there? It has to do with seizing your property sometimes, seizing you as an arrestee. So think about all of the contexts in which the Fourth Amendment apply, because it's the easiest one to violate. So know your Fourth Amendment inside and out, and know when you can search and know when to call timeout and get that search warrant. So we've seen a recent application of the Fourth Amendment with the Mar-a-Lago search warrant that was served to former President Trump's residence. It's the first time that's ever been done, a search warrant served on a former president. It all remains to be seen. But the Fourth Amendment limits the power of police to seize and search people in their homes and their property. And it ensures that evidence that's gathered improperly is going to be excluded from trial if there is a trial at some point, in the broad sense. A person's home is the person's castle. So you need a very high standard to get into somebody's home to search it. Now we carry around a cell phone with just about every single piece of data and or memory. It's basically your storage unit in the size of a phone. So the Fourth Amendment does extend to the phone, and be very careful when dealing with cell phones. Sometimes you need a search warrant for that if you don't have the consent of the person you're talking to. The dreaded Fifth Amendment. It's a protection against self-incrimination. So the Fifth Amendment comes into play when you're about to interview somebody as a police officer. The Fifth Amendment is you can't compel someone to tell you what they did if it's going to incriminate them. They don't have to incriminate themselves, and that they cannot be tried for the same crime twice. We see that that's kind of different nowadays, especially in the Breonna Taylor case, where one of the detectives who was charged in the state and exonerated, but the federal government is claiming a different sovereignty and charging almost the same charges in federal court for the same officer. So their argument is that he's not being tried for the same thing twice. He was acquitted, and now this other sovereign area is going to pick that up. So when you hear Sixth Amendment, think about the right to a public trial, an impartial jury without delay, speedy trial, giving defendants the right to hear the charges against them, a confrontation clause, to call and cross-examine witnesses, and to retain a lawyer to defend them in court. As a cop, that's generally what you're going to deal with the most, the Fourth, Fifth, and Sixth. When you read somebody their Miranda warnings and you write in your report, they invoke their Miranda rights. You're not helping the detectives, or you're not helping the prosecutors by just saying that. Because remember, when somebody invokes their rights, they're either invoking their Fifth Amendment right to remain silent, the self-incrimination part, or the Sixth Amendment right to an attorney. And they are two different animals. So the difference between the Fifth and Sixth Amendments, as it applies to Miranda, if they just tell you, look, I don't want to talk anymore, that's the Fifth Amendment kicking in. You could probably recontact them at some point, as long as there's some kind of cooling off period. When they say, I'm not talking to you because I want my attorney, that's the Sixth Amendment kicking in. So the Sixth Amendment is a lot more important, because it's pretty much hard and fast. Stop talking to this person until you get them an attorney, and do all your talking through their attorney once they tell you that. Because those are two different, very different things. And you can recontact somebody if it's a Fifth Amendment invocation, but you won't be able to recontact them without their attorney if they invoke the Sixth Amendment. Here's that bonus tip that I was telling you. You're going to come across so much more honest to the prosecutor, to your supervisors, even to the defendant, if you just understand the importance of the Fifth and Sixth Amendments and those Miranda. It's a very intimidating and daunting process, and it's a very delicate balance to try to get somebody to talk to you and try to get them to tell you what they did without reading them Miranda and knowing when to read it. And there's no app on your phone that's going to go off to tell you when to read the Miranda. You can talk about anything. You can gather their biographical data. That's covered in the Constitution as well. That doesn't fall under the Fifth or Sixth Amendment. All of this stuff you can talk to them about. You may not be able to ask them questions specific to the case. Make sure that you're specific about how they waived it. And let's be fair. Nobody has the obligation to talk to you, and nobody has the obligation to tell you anything. and nobody has the obligation to make your life a whole lot easier. There isn't any obligation. Now, if they feel like they want to clarify some things or they feel like they want to, try to bamboozle you, that's when they talk to you. And that's normally when we get them to confess to what they did. And the confession we should be looking for is simply the truth, not for them to confess, but for them to give the full story with full truth. Because I'm going to ask this question to you. What is the difference between the Fifth Amendment and the Second Amendment? So if you're pro-gun, you are pro-2A, and you believe everybody has the right to bear arms, why would you be anti-Fifth Amendment where people have the right against self-incrimination? There's no difference between the First Amendment, Second Amendment. They're all very important, and they're all constitutional guarantees. It may frustrate you, but look at it this way. It'll make you a better cop because you have to take the statement that you're given or the lack of statement that you're given and investigate around that and come up with a good investigation to charge that person. I'm Drew Breasy for Failure to Stop. Thanks for listening. Make sure you like and subscribe, and I'll see you on the next one.